Anyway, IP. You know what IP stands for, right? IP stands for intellectual property. And intellectual property can be categorized into 4 different forms. Which forms do you think you may have heard of? Which form do you know of intellectual property? Okay, by the end of this talk, you'll be able to realize that you've seen all of this and probably didn't realize. Maybe somebody else can try. Do you know any form of intellectual property?
Yeah, I know from the, like, if you want to develop a product, you can own your product. So that is some kind of your product has to own.
Okay. Somebody says patent.
Yeah.
You know patent, right?
Yeah.
Okay.
Copyright.
Copyright. I'm sure these ones you've always heard about, right? Which other one? Trademark. The table.
Yeah.
No, they didn't really look at my notes. And the last one. This one you all know. What does Coca-Cola do? No? There you go. 4 forms. I'll give an example. I live in South Africa, and there is a South African football team is called Bafana Bafana. So Bafana Bafana, South Africa was hosting the 2010 World Cup, right?
Yeah.
And was a very exciting time. Prior to that time, somebody in around 1996 decided to go and register the name Bafana Bafana, registered legally. 2010 comes, the government is so excited, Bafana Bafana, South African team. After a while, somebody comes and tells them, no, don't use that name. It's the World Cup. World Cup has started, it's 2010. The person who registered has got all the paperwork to show that he owns the name Bafana Bafana. So the government is, what do we do now? Why don't you be patriotic? Why don't you give the name? He says, no. Being patriotic, no. At the end of the day, the government decided to settle with him. They gave him 8 million rand, which is equivalent to 800,000 US dollars, to use the name for a period of 2 months. And that was before the World Cup. You know, there's always the build-up. Now, when the World Cup had started, they kept on. He went back and said, you guys, you don't learn, you don't listen. You're still using the name. The agreement was that you use the name for only this period of time. You're exceeding. So then the government said, okay, fine, let's give you some more money so that we can use the name. Eventually, the government had to pay close to $40 million to just buy the name from that person. Yeah, these things happen. These things happen. That's trademark. So you see, with trademark, you need to continuously register it. So there's ways of protecting your items through a trademark. For instance, I'm sure you've seen counterfeit goods where they say, for instance, MasterCard, and then you reach a certain place where it's written Master Beef. I'm sure you've seen this one here, Kentucky Fried Chicken, KFF, with everything else there. So you see, they're trying to get onto that power that the trademark has generated. That's the reason to why sometimes if they say, no, we've got here a computer called Proline, and we've got a Dell. How many of you guys will go for a Proline? How many of you guys will buy a Dell? Because you've heard of a Dell, right? They have put a lot of emphasis on developing that name. You understand? Even if it's not as good as the Proline, but just because you feel that's the power of a trademark. Moving on to the next one, which will be copyright. Copyright, we all know about this, right? We write books, we write scripts, the movies and all of that. The interesting thing about copyright, you always own the rights to your material unless maybe you give them away. So for instance, sometimes when you publish your work, the publishing house will take your work and say, now we own it. If you need to use your work, you need to seek permission from us, and so on and so forth. But if you own your work, it's yours. You own it. You have all the rights to that work. The interesting thing about...
I want to point out that one really good example of that is if you
Yes. Yeah. Yeah. Very good.
So continue, and then we'll go over the discussion in that one.
When you send it to the journal is going to ask, has this appeared before? If your thesis has appeared before, the journal, you need to talk about it. The
Yes.
journal will be okay, but you need to talk about it.
Yeah. So that's one example, copyright. And well, for those of you who like to write scripts for videos or movies, the interesting thing about copyright is that when you die, it doesn't end there. You'll still reap the benefits 50 years after you're dead. That's the good thing about copyright. So that's why you see people who write these scripts for movies and all of that, even in the grave, still having a return on their investment. Anyway, so that's with copyright. Then the other bit is trade secret. We've always heard of the Coca-Cola trade secret. It stays in the family. No, it's only the family members that know this. And if you ask the person, what does the formula look like? They don't patent their drink. They won't patent it. You can take the drink and try to analyze. You'll find that you probably won't know what's really causing the taste for Coca-Cola. We all know if you test Pepsi, you test Coca-Cola. For those of us who drink Coca-Cola, we'll be able to tell the difference between the two. They have what they call a trade secret. KFC uses the same thing. I'm sure McDonald's also uses the same thing. So that's what they call a trade secret. And the other bit is using patents. And now that's something that we probably are very familiar about. One interesting thing about a patent is that it's only awarded for a period of 20 years. So when you register a patent, the very first time you register a patent, you have a provisional patent. So once the provisional patent is done, they start counting from that time. And ideally, your provisional patent will last for a period of 1 year. So if within that 1 year, you have not been able to do the work to convert your provisional patent into a full patent, where you have to do the PCT, the full patent filing system, then you run a risk, because if somebody else comes up with the same idea, they will say, no, this idea fell off the system, so it's open to everybody. So ideally, what people usually do to protect their ideas, now like people who want to design or invent new things and they feel that it's going to be lucrative in the long run, they will file the provisional patent. Once they have a provisional patent, they can disclose to people because they're already protected, but they're protected for that period of 1 year. So once that period elapses and you've not generated enough data to file for a full patent, then there's going to be a problem. But if you have enough data to compile your full patent, then things will be looking up right for you. So remember, with patents, you can patent a design, you can patent a method. There's different ways you can be able to do that. So what happens, like in South Africa, most of the universities have adopted what they call technology transfer offices. So with the technology transfer office, you go there, you tell them your idea, they will sit down and help you to write it up, because you won't be able to write. How many of you have read a patent before? Or have seen a patent before, okay? About 2 people, 5, 6, 7. There's so many clauses, number 1, number 2, number 3, number 4, and then they go back and reference in clause number 1. So it's quite interesting. And with a patent, you have to fully disclose, because if you make a mistake of not fully disclosing and somebody else figures it out, you'll be in trouble. An example is with the drug Viagra. They went and patented, but they did not fully disclose. Within no period of time, other versions came out, and they tried to take those people to court, but that information was not there in the patent information, so they had to lose the case. So patents are usually a very good way of protecting your ideas. However, we don't work in isolation. So for instance, if you're going to collaborate with somebody, it doesn't mean that you cannot co-share your intellectual property, because in this world and age, there's no way we can accomplish anything just by ourselves. So if you're going to work with people, you need to know at which level you're working with them. Are you working with them on a partnership or cooperation kind of level? That way you can be able to, you've heard of MOAs, memorandums of understanding, or memorandums of association. You can have those too, and within the MOAs, they state out clearly what this party will do and what that other party will do. And usually there's the most interesting clause there in South Africa. If you're going to work with a South African institution, is usually the IP part, where they will say, okay, fine, there will be joint sharing of the IP, and they'll go into and all of that. So that way you know everything is okay. However, if you're going to work with a person, and some granting bodies, especially those that really fund industrialization or commercialization projects, they would want to see some sort of a service level agreement. So the service level agreement says, I can do so many different things. You want me to do those things for you. Therefore, let's have an agreement. You define the terms. You pay me. I do the work. Then I give you the report that you're looking for. So that way, I won't own any bit of the patent. The patent will wholly be owned by yourself. So yeah, in a nutshell, I mean, this is really a lot of information, but that's as far as I can go.
Thank you very much.